morning, and thank you for the invitation. I'm happy to be here and happy to see people I already know, and nice to meet everyone else. Today, you've already heard from Mr. Faisal about the DGIP, and I'm going to cover the overview of what you can expect when you file a patent application and what you can do with your patent after you receive a grant, and what you can use your patent for in enforcement. And I'll touch a little bit about industrial design at the end. First, I want to talk about the overview of the Indonesian market. Indonesia is the fourth most populous country in the world, and quite young. The median age is about 29, and the approximate GDP growth is 5%. The result, we had this year a presidential election, and the result of the presidential election is that Mr. Prabowo Subianto won, and he is from the same political party as the previous president, so we don't expect big changes in the direction of how the country is in the next few years. I want to start talking about patent protection on when you first start filing your patent. What are the things that you need to do? So all of the IP applications are e-filing. The DGIP has streamlined the patent application process since COVID-19, and things have been running really well using the e-filing. So all the submissions are submitted electronically, and the formality documents such as power of attorney, statement of ownership of the invention, and deed of assignment are all simply signed, and they can be submitted electronically. Two things. The application must be translated to Bahasa Indonesia, and from my team, from my experience, we have tried some AI translation, and it's not completely accurate yet. I'm guessing in the future it will be, but some of the translation, they don't detect the context of the application. So I think human translation should still be done in the near future. Indonesia is a member of the Paris Convention, and in case you filed a patent application using Paris Convention, you would have to provide a priority document that is certified. So this document also can be submitted electronically, so it's easy. Clients don't have to send the actual copy anymore. And Indonesia is a member of the PCT, and the deadline to file national fees in Indonesia is 31 months. There is an option of filing late, but the reason of filing it late has to be non-intentional. After the application is filed, the publication takes place no later than 7 days after 18 months of the filing date, and the publication period is 6 months. Substantive examination must be requested within 36 months, but you can do this at the time of filing, and if you don't want your patent application to go a little bit faster, you should request it at the time of filing. There is divisional applications available, and it can be filed as late as before grant, but I don't recommend that. It should really be filed after you receive the first office action. There are options for accelerating your patent applications in Indonesia. The first one is you can request for early publication. So usually publication is within 18 months from the filing date, but if you request early publication, it will be done within the 6 months from the filing date. And Indonesia has 2 PPH programs, one with Japan and one with Korea. If you have a granted corresponding Japanese patent or Korean patent, you can conform your Indonesian patent applications, claims, and submit that and request for a PPH, which from what we have seen so far, that PPH can be can increase the speed of grant within 2 to 3 years from filing the application, which we think is pretty fast. If you compare to normal time of grant, it's about 4 to 6 years. The next program, which we haven't had too many applications from, so I can't speak from the experience, but its aspect, it's with using the granted corresponding patent from ASEAN countries to speed up the examination. And then the last option is if you have a granted corresponding patent from a major jurisdiction like UK, US, EU, Canada, Australia, you can file a voluntary amendment, submit that, conform the claims, and it will make the examiner's life a little bit easier when examining the patent application. Mr. Faisal already talked about the simple patent in Indonesia, or called the utility model in various other jurisdictions. So I'm not going to go into too much detail of it. But the definition of simple patent is that simple patents are granted for new inventions or improvements to existing products with practical uses and industrial applications. I do want to go into that the simple patent is substantively examined in some other jurisdictions. My understanding is it's not substantively examined. So you have to have novelty and industrial application. And the substantive examination request must be requested at the time of filing the application. With the job creation law, the latest amendment, the timeline for prosecution of the simple patent has significantly shortened, so the application has to be published in 14 days, 14 working days, and then if any opposition is filed, it's considered during the substantive examination, so that'll shorten the timeline for the prosecution. And the grant or refusal will be issued in no less than 6 months from the application filing date. Mr. Faisal also already mentioned the certain conditions that makes patents not patentable, and I want to touch on 2 of the major obstacles. So one is computer-related invention, the other one is going to be pharma. So let's look at computer-related invention first. So the patent law says that rules and method which only contains computer program cannot be patented. And in the explanation of the law, there is an exception that says that if a computer program possesses specific characteristics or instructions that have technical effect and can solve tangible or intangible problems, it is considered an invention and eligible for a patent. If we look at examples of inventions that can be patented, there are 2 here. So an algorithm is an effective method that can be expressed within a finite number of well-defined instructions for calculating a function, starting from an initial state and initial input. The instructions describe a computation that, when executed, exceeds through a finite number of well-defined successive states, eventually producing an output and terminating at a final ending state. The transition from one state to the next is not necessarily deterministic. So some algorithms, known as randomized algorithms, and incorporate random input. I think this is pretty broad for patentability. And the other example is an encryption of information by way of encoding and decoding to scramble so that the information cannot be read by others. There's also some guidelines in the patent examination procedure. It says here that a computer program can be regarded as an invention if the program has a potential to provide a technical effect when executed on a computer that is beyond a normal physical interaction between a program and a computer. And there's also an example of what is not providing further technical effect. That is, electric current is not going to be patentable. So again, I think this is a really broad interpretation of patentability. Here are some examples of claims that have been patentable. a method for operating a data processing system, which comprises steps A, B. A data processing apparatus system comprises means for executing the method of claim 1. A data processing system comprising means to execute step A, means to execute step B. A computer program adapted to execute the method of claim 1. Computer program comprising software codes adapted to execute steps A, B. A computer readable data carrier storage comprising the program of claim 3. A computer readable data carrier storage comprising instructions which cause the data processing apparatus system to execute steps A, B. So as you can see, there are various types of method claims that can be patentable. And here is one specific one owned by Smart Sky Networks that this patent has been granted. It's a method claim, and I have underlined the relevant parts that shows like the finite step that shows a beginning processing step and also a terminating step. So I think these underlying parts I can qualify this claim as patentable. Next possible hurdle for filing a patent application in Indonesia is pharmaceutical-related invention. The patent law excludes invention of new usage of an existing and or known product and or new form of an existing compound which does not result in significant increased efficacy and has no related chemical structure differences from the known compounds. And also any method of examination, treatment, medication, and or surgery applied to humans and or animals are not patentable. I just want to mention briefly that in some countries, like in the US, they have something called the patent term extension. And it can be requested if it's a pharma or a biotech application, and the examination period is taking longer than usual. And you know, if that's the case, then in the US you can request for an extension. But in Indonesia, there isn't such extension. So even if the application is examined longer than usual, you cannot extend your patent, the life of your patent. Now let's look at the claims that are not patentable. So method claims for medical treatment and second medical use claims are not allowed under the current patent law. Examples are a method of treating lung cancer with a compound according to claim 1, use of compound X for the treatment of lung cancer. But these claims, if it is supported in the specification, you can amend them and make them patentable. The acceptable method claims are use claims according to the EPC 2000, which is the limited purpose product claim, and the format is compound X for use to treat disease Y. So for example, you have a compound of claim 1 for use in treating lung cancer. This would be patentable, but again, you have to make sure when you're drafting the patent application that this is supported in the specification. Otherwise, the amendments would be outside of the scope. Now that we have gone through filing and getting your patent granted, I wanted to talk about keeping your patent protected. You have to pay an annuity fee, and the first annuity fee is an accumulated annuity fee from the first year until the year patent is granted plus the next year, and that has to be paid in 6 months from the grant date. And then any subsequent annuity fee must be paid 1 month prior to the anniversary of the filing date. There is a grace period available, but you cannot just miss the deadline. You have to file a request for extension within 7 working days before the deadline. And there's a penalty, you have to pay 100% more, so it's not recommended. And you have to pay the late fee within 12 months from the request of the extension. Now, Indonesia has a rule that you have to implement your patent once it's granted. The definition of implementation is that you have to make, import, or license the patented product process method, system, or usage. If you don't do that, then within 36 months, a party can submit a request for compulsory license. But in the case that your patent is implemented and is detrimental to public interest, or a development of a patented product could not be implemented without using the already existing patent under protection, you don't have to wait the 36 months to request for the compulsory license. Some rules for requesting compulsory license is that it has to be filed in writing to the Ministry of Law and Human Rights, and it's always going to be a non-exclusive license, but it has to have a purpose of meeting the Indonesian market. And there is a caveat for semiconductor specifically, that if you request for a compulsory license for semiconductor technology, it has to be for non-commercial public interest, or it is just to deal with an unfair business competition. And here is another important thing that to show that you are implementing your patent, you can license it, but your license agreement has to be recorded at the DGIP. So unless it's recorded and published, then your licensee cannot take action on behalf of you. So if there was infringement, they cannot take action on behalf of the patent owner. And then also another important thing is to keep your the patent owner up to date. So if there was a change of name or anything like that, you need to keep that up to date. And if you are recording these changes during the prosecution of the application, then it'll just be called change of patent application. But if you do the recordal after the patent granted, it's gonna be called, recordal assignment. And I just listed the documents that you need to submit with your request. After you submit your request, the application for assignment is examined, and it will be within 14 days recorded if the documents have met the requirements. Briefly talking about enforcement options. So you have your patent, you're keeping it, enforced, and you have found that there is or company infringing on your patent, and then you have these available options that you can take action against them. You can ask the other party to do alternative dispute resolution or arbitration. But the more common routes are the criminal and the civil routes. For the criminal enforcement, you would have to contact the state police or the civil servant investigator from the IP office to conduct a raid on the infringer, and then from then they will examine the case and pass it on to the prosecutor to consider and file a criminal action against the infringer. But there is a requirement that you have to do mediation before litigation commences for all criminal offenses. But if you're going to the civil route, then you would file your infringement claim at the commercial court, and the commercial court is the court dedicated to examine patent infringement cases. In Indonesia, there is no specialized IP court to only examine IP cases. After the case concludes, and if you need to appeal, then it will be appealed directly to the Supreme Court. So it's 2 layers, not the 3 layers. I listed some penalties for infringement. For criminal penalty, the fine can be up to about $218,000 and 10 years imprisonment. And for civil, it really depends on the case. If you can submit a lot of evidence that the plaintiff has suffered severe damages, that'll help your case, and because there's no specific benchmark on how the judge can decide to rule on damages. So the better evidence you have on the damages, the better it will help your case. Once infringement is proven, a judge can order confiscation and destruction of the infringing products. Okay, so the reason I added a little bit about industrial design is because patent infringement cases in Indonesia doesn't occur a lot. I think per year, maybe 5 to 10. And so the judges are not super familiar with patent infringement cases, and when you litigate, you would have to have really good expert witnesses to explain your invention and to explain, why there's infringement, and that can be difficult in some instances, right? So if your client's products can qualify as industrial design, I would suggest to also file industrial design application, because that is easier when you have to litigate for infringements. So the definition of industrial design is the creation of a shape, configuration, or the composition of lines or colors, or lines and colors, or the combination thereof, in a 3 or 2-dimensional form which gives aesthetic impression and can be realized in a 3 or 2-dimensional pattern and used to produce a product, goods, or an industrial commodity and a handicraft. Indonesia is not yet part of the AIC system, and so when you file a design and you want to claim priority, you have to file it in 6 months after the GMP. And if the design is being examined for novelty, partial design is acceptable. You have to indicate that by dotted lines. And then a set of design, multiple design application is available as well, but the definition of a set of design is that it's products within the same classification, and it's not various embodiments. So if you have a set of chairs and a table, you can file that as a multiple design application. But if you have a chair with various embodiments and with little changes here and there, it has to be filed in separate applications. Oh, and the good thing about industrial design is that there's no annuity fee to be paid. So we've come to the end of my presentation, and I just wanted to give you key takeaways. Only 4 things. Be aware of the relevant deadlines, review your application for patentability, make sure your patent remains protected after grant, and then know that you have measures you can take against the infringer. And that's the end. Thank you.